Hello, hello, hello. We are back with another agency agreement. Chris, are you ready for this one?
Yep, the exclusive buyer agency agreement. And actually, you know what? Weirdly enough, this is by far the most common agency form that most people are going to use. And here's why. There are some agents out there that specialize in listing. But having said that, when everybody joins the business of real estate, almost all of them concentrate on buyers to start with.
And speaking of talking with buyers, one of the first things I want to point out is that this contract is between the buyer and the firm. This is not between you and your buyer. When somebody says, hey, can you help me buy? They're hiring the firm and you are an agent of the firm.
True. I hope they love you. I hope they work with you forever and you make tons and tons of money with them. But actually, the firm owns this relationship. And if for some reason you were to leave prior to contracting with this buyer, it's very, very possible that you may be required to leave this with the firm.
Exactly. All right, let's jump right down to our next section where we're talking about the working with real estate agents disclosure. And this is just to ensure that you have reviewed. Remember, you can't just give, but you have to review the working with real estate agents with your buyers. When is that point? When do they have to do it by?
Could that be first substantial contact?
I think it is first substantial contact, right?
If you're not waking up screaming that in a pre-licensed class, you haven't been in class long enough.
That's exactly right. So I will point out, if you've watched our other videos, if you haven't, you should go check them out. We did an offer to purchase and contract, and we've got an exclusive agency agreement, exclusive right to sell, I should say. But this one is the shorter of all of these contracts because we're talking about, hey, buyer, I'm going to represent you, but we don't know which house or what property you're going to sell. So this is going to be a little shorter. And I mention that because the very first section, section 1 says type of property. And it is important that you say, hey, am I helping you buy residential? Am I helping you buy commercial? And then make sure you do put in a general location.
Yeah, just real quickly on that. A lot of times when I teach agents to talk to buyers, I ask them to ask that buyer a question. Are you working with another agent? And sometimes the buyer will say no, or maybe they'll say yes, I don't know. But my next question to follow up is, have you signed anything with another agent? Now think about this. It is difficult to have two exclusive buyer agency agreements. It's difficult, but it's not impossible. Because look at what Kandyce just pointed out. If someone's coming to the area to buy a residential property and also a commercial property, it's very common that they might have two separate exclusive agreements. Or if someone's going to look in Charlotte or Raleigh because they're going to be transferred with IBM and they don't know which location yet, it's possible they would have an exclusive agent in Charlotte and one in Raleigh. This is not insignificant information that we're asking early on.
And with section 2, the effect of the agreement, what we're saying is that buyer is agreeing to work with that agent for all negotiations and things like that through the firm. So it is important to have that conversation, especially when you have buyers coming in from out of town. Okay. So let's move on to our next section, the term of the agreement. And when we say term of the agreement, we're talking about the length. And we know, thanks to commission rules, all agency agreements, if they're going to be for sales, must have an exclusive
Must have a start date.
Must start date and an end date, and they cannot have an automatic renewal clause. Almost tripped over my own tongue there, right? So we go ahead and we talk about when it begins, right? And then we also talk about when it's going to terminate. Now, we did have this addition, I guess it was a couple years ago, where if somebody's buying more than one property, you can choose a different date so that you don't have to keep filling this out over and over again. People who work with investors.
Right. Great point.
All right. Section 4, compensation of the firm. Chris, tell them about it.
Well, it starts off talking about a retainer fee. I will talk about the market that I am in. It's not common to have a retainer fee currently. That may change over time. However, notice that this contract gives you the ability to put a number in there. With gas prices going up, it may be that you say, you know what, buyer, I would work with you, but you got to give me $500 up front. And then you just simply answer a question that it will or will not be go to the compensation that's due at the time of closing. So keep in mind, this is a thing you can do. It's not a thing that you have to do. I suspect that you will find that it will be market dependent. When you get to 4B, this is the one that you're really going to want to study. Buyer agrees that firm's fees hereunder shall be in the amount of, and it may not surprise you to know that that's typically a percentage. I would highly recommend that you know the percentage in the market that you work. And now listen, here's a couple of things we know. We know that the market can't set the fee. In other words, the MLS can't set the fee. The real estate commission can't set the fee. Nothing like that. But you'll know what's common in the areas you work. I would ask that you be specific there, because remember, this is a contract. This is a buyer agency agreement is a contract, and the terms must be specific. And then it'll go into how you have earned that compensation. Keep going, Kandyce.
Well, I'm going to just point out that, I love money. And so I think that whether it's a retainer fee or you're talking about your commission, you make sure that you get compensated what you feel like you should for your services. And yes.
Yeah, and just a added notice on this. As a agent of a firm, this money will actually go to the firm or the broker in charge, and it will be subject to any splits that you have with your firm. However, that's not the buyer's business so much. What your split is with the firm. All they need to know is how much you're making for acting on their behalf.
How much is the firm making?
Correct.
All right, so we've got 3 sections here. And the first section says, look, buyer, we're going to look to try to get the fee from a listing firm, right? And they usually have something in the MLS. Or we're going to try to get it from the seller if there is no listing firm. And the buyer is allowing us to have that money. But probably the most important section, I think I have to change colors for this one, right? This section 2, where it says, if buyer purchases a property where the compensation offered by the listing firm or the seller is less than the fee, or where no compensation is offered by either the listing firm or the seller, the buyer and the firm agree that the buyer will pay the difference between the fee and the compensation offered unless prohibited by law.
Okay, that's a lot of words, but it's extraordinarily important. And I'm going to use some numbers here, but again, don't read anything into these numbers other than they're for example purposes. Okay, so let's say that in 4B, I believe that I'm going to make 3% for acting as your buyer's agent. What 4B1 says is it's not uncommon for that 3% to be paid either by the listing agent splitting their commission with me, or if it's a for sale by owner, the seller may pay you that. Now, it's interesting that the person who pays you does not determine what your agency is. Do you understand that I can be a buyer's agent and I can be paid by a third party? So all that's addressed in 4B1, okay? That is very common. However, notice that what it said in 4B2 is that, well, what if there's no compensation offered? I still should be compensated for my work. And if there's not another party compensating me, then buyer, I expect this 3% to come from you. And this will actually frame the way you work with your buyers. Hey, buyer, that house is listed in MLS and the listing firm is offering me 3%. Boom. That's what our agency agreement says. Hey, buyer, listen to this. Hey, buyer, the MLS says that I'm entitled to 2.4 and you said you're going to pay me 3. So I anticipate that you will pay me the difference of the 0.6%. It's a great conversation to have with your buyer. And this is so important that there's currently a class action lawsuit going around on this. So I would ask that you be specific and have conversations with your buyers to help them understand this.
Yeah, I just like to get paid. So I like to say, hey, buyer, I'm going to try to get paid by somebody else. But if they're not willing to pay me, you will be paying me.
The old Working with Real Estate Agents brochure has been converted to a Q&A. It does an amazing job explaining this to buyers if you're having trouble with it.
I love it. All right. And then there is a section 3 here, which is talking about, look, sometimes, especially with new construction, we will be offered a bonus or something like that. The buyer's agreeing to let us have it. We just need to make sure that we disclose this. You cannot take extra monies and not tell the buyer about it.
To make this short at this point, but to make your study really hard if you're in a pre-licensed class, this is Commission Rule 109. If you're being compensated by a third party, you have to disclose it in a timely manner and reduce it to writing no later than the offer to purchase. Once you understand that, I promise you're getting 2 questions on the test.
I just want to say you're showing off your knowing of the numbers. You don't have to know the numbers for the test. He just likes to show off. All right, let's move on.
I may have made it up.
So section C, this is telling us, well, when have I earned my money, right? And this is going to be if the buyer or anybody working on behalf of the buyer either directly or indirectly enters into an agreement to buy a property, or if they actually buy it, right? Then they owe us a commission, or we are owed a commission, whether it's them paying it or a seller or somebody else paying it. And then the next section too says, look, if within a certain amount of days after this agreement, the buyer decides to buy something that we showed them, then they need to pay us our commission.
Yeah, this is, listen, buyers and sellers are not stupid. If you have a 3-month agreement with this buyer and you show them a house on 2 months and 30 days, they may be thinking to themselves, wow, if I wait till tomorrow, I can buy this home and I won't have to worry about the commission. I'll put that commission in my pocket. There's a protection period in here that keeps them from circumventing you. You don't like to think that people will do things like this, but you protect yourself by contract.
People are peoply.
People are peoply.
All right. And then our section 3, it basically says, buyer, look here. If I find you a property to buy and then you default, they're not talking about backing out during the due diligence, but they default on the contract, then they still need to make sure that you're getting paid.
Correct.
Now, how often does that happen in real life, Chris?
Okay, keep in mind that reality and the test are two entirely different things. This contract says how, in fact, you could be paid under these circumstances, but recognize 99 out of 100 times, buyers are paid a success fee for getting people to the closing table.
Yeah, I don't like reality so much.
I did actually collect $12,000 on that case this year, though.
Hey, I love that. See, it is very important. All right, and then when are you going to get paid? You're going to get paid after settlement and after closing. And we know, because we've had this discussion in class, or if you've already, been licensed, we know we talk about it all the time. That's not going to happen until we record the deed. And by we, I mean the attorney. And then just remember, as somebody who's worked in offices, once that check is cut, it's not cut directly to you. It is going to be cut to your firm, and then your firm's going to have to process it, and then you can get paid. So just because you have a closing on Monday does not necessarily guarantee you will have a check to put into your bank Monday evening. Okay. Anything you want to add there, Chris?
No, I was looking ahead at the note. You ready to move on? And
I am.
This is just a quickie. And if it's never occurred to you when you're acting as a buyer agent, if you're being paid a percentage of the sale price, recognize the fact that as a buyer's agent, you would make more if the buyer paid more. But again, you're a fiduciary of the buyer, so you always put their best interest first if you're acting as a buyer's agent. It doesn't matter how much you're going to make. What matters is, are you representing them in the manner in which they want to be represented? Mm-hmm.
Kind of along the same lines, kind of, sort of, we do need to point out that if I'm the buyer and I assign, I hired Chris and his firm to represent me, that doesn't mean I'm going to be the only buyer that they have. So it could be happen that maybe another agent in his firm is showing another buyer a house, and they just need to be aware of that.
Yeah, and it also talks to the buyer about the idea that, listen, in this agreement, the buyer is exclusive to us, but I am not exclusive to other buyers. I make my living by working with other buyers, and we just go ahead and express that so they understand the nature of the relationship.
Exactly. And as long as you're talking to them about the relationship, talk to them about what your duties are as a buyer's agent. You're going to help them to find a property at the price and terms that they're looking for. You're going to make sure that you present all offers that they have, written offers or counteroffers, to them, and make sure they know about them. And of course, we have to disclose all material facts relating to the property or the transaction, right? Because that's part of our job.
Yeah, just real quickly on the firm's duties, keep in mind, again, your fiduciary, your trust relationship that you have with your buyers there, what we refer to as agent level duties. And part of those would include that we're doing this research for the buyers. I don't know if it's included in that little list there, but even things like CMAs to help them understand the value of the house. That's why they hire agents, is to do these things that they're either not qualified or don't have the time to do.
Exactly. So I'm going to scroll over, or I should say down, to number 7, disclosure of the buyer's name and mailing address. And I think I can sum this up by saying, buyer, you're going to write an offer, and more than likely it's going to have your name on it. If you don't want your name on it, we're going to have to call an attorney.
Yeah, thank you for keeping that short. Yeah, that's true.
Now, Section 8, what is that about here, Chris?
So again, we're seeing the fair housing language here, and you'll hear this in all agency agreements, part because it's just a great idea to say that agents do in fact follow fair housing laws. And by the way, buyer, I expect you to as well. And then the other thing is it's required by Real Estate Commission rule that it actually be in all of these agency agreements. So you will in fact see it, and it'll look just like that. That's the language that's required by rule.
Now, the next section, speaking of fair housing, the buyer's letters to the seller. We know that sometimes buyers like, you know what, if I plead my case to the seller, they might take pity and take my offer over somebody else's, which is a great idea up until we realize we could be breaking state and federal fair housing laws, because there could be unconscious bias or actually conscious bias. Knowingly they could do it, and that's a problem. So you just want to have a conversation with your client, perhaps with an attorney, about whether a buyer's letter to the seller is a good idea.
Yeah, we've been warned on this by fair housing organizations, the Real Estate Commission, and the Association of Realtors. If a buyer wants me to deliver this letter, I am going to vehemently describe to them that I am not going to deliver this letter. And I think I would actually be supported by the entities I mentioned.
Yeah, I think that, just no. All right, let's go on. We've got our buyer's duties, because yes, we're doing things for our buyer, but we need to make sure that they promise that they understand they're working with us exclusively, and they're going to tell us about any properties that they see. They're going to make sure that they only go to properties by appointment that they make through us, because otherwise it's just creepy to be looking in people's windows. And they're going to do all their business negotiations and communications through the firm. Right?
Yeah, on this, you think my buyers love me, they're never going to do anything outside of this. Let me tell you something. Every weekend you're working with a different buyer. The buyer you're not working with is going to be out looking at open houses, and they're also going to be looking at new homes. So they need to understand the nature of the relationship so they do not break the exclusivity that comes. They could actually end up being required to pay 2 commissions if they break the rules of this.
Nobody wants that. Well, I guess the 2 agents do, but yes, that's not what we're looking for. So Section 10 is about other professional advice, which is basically us saying to this buyer, I am a jack of all trades and a master of none. You've heard that saying?
I've heard it, yep.
Mm-hmm. And that means I might know a little bit about plumbing. I might know a little bit about electrical or anything like that having to do with houses, but I am by no means an expert. And if that buyer wants an opinion, especially on the status of the house, the condition of the house, they need to pay an expert. Not only do they need to pay for them, but they need to listen to that expert. We can't make those claims or tell you anything about the house unless we're licensed to.
Yeah, while I'm your agent, I do consider myself to be almost a project manager, in that I'm going to pull these people together. I'll be happy to order any test for you that you want. But a couple of things. 1, recognize that it's outside of my expertise. And 2, buyer, you need to pay for it.
Yeah, I don't want to pay for that. And I'm guessing you don't either. All right, and I guess that's you, Chris, not the buyer. But they probably don't want to pay. All right, we make sure that we give a sample copy of the offer to purchase and contract for reviewing. And we're going to hopefully give them a copy of the professional services disclosure and election form, which talks about all that stuff we just talked about.
Interestingly enough, with the professional services disclosure form, our E&O policy gives us a discount if we get that signed by every buyer. The idea being that there will be a record of whether we suggested they get an investigation and whether, in fact, they accepted it or not.
Now, everybody may not know what E&O insurance is, Chris.
It stands for errors and omissions. And one of the things, if you're interviewing with firms, you might want to make sure that they have a vibrant E&O policy. It's basically malpractice insurance for real estate agents.
Agents mess up.
Sometimes they mean to, sometimes they not, and your E&O will cover you if you didn't do it on purpose. They will not cover you for fraud.
All right, let's move on. Home warranty. Talk to your buyer about the fact they may want a home warranty, they may not. You have a conversation. Are they looking for it? Are you looking for it? And sometimes there is a fee involved that could be offered to the firm from the company. I'm not a big fan of that, but if you remember, if you're taking a fee, you have to tell your client about it.
Yeah, there are some questions about how this would be affected by RESPA. So just as a pro tip, you may want to go back and look at your RESPA notes and see whether this will be a violation of RESPA, and talk to your home warranty companies. They are the best at describing this to you.
Real Estate Settlement Procedures Act, RESPA. Section 12 reminds the buyer that we have to keep all offers confidential. We can't tell the detail of their offers or anybody else's offer without express permission. And then Section 13, we do have additional provisions, which I don't think either Chris or I have anything that we think should be put there, but just in case something randomly happens, that's where you put it.
Correct. Yeah, let's avoid it if possible.
Now we're going to get to the big part, the dual agency.
Let me take you back for just 1 second.
Sure.
I'll make this quick because I don't think it's radically important. One of the things that's interesting about the confidentiality of offers paragraph, everything that Kandyce said is exactly correct on there, but we actually caution the buyers to not assume that their offers are confidential. And you say, well, gosh, that sounds counterintuitive that we can't tell what the offers are, but we're telling them not to assume it's confidential. The reason is the seller can tell anybody they want to. They are not bound by the same rules that we are. So, the buyers need to understand once you make these offers, we can't control what the seller does, only what agents do.
In fact, we can't even control whether or not there actually is another offer on the table, because sellers, they don't have to tell you. And sellers' agents should get permission before saying anything. So,
correct.
All right, now to dual agency, which you know how much I love dual agency. So let me just kind of break this down. All of this up until this page was creating an exclusive relationship between the buyer and the firm. And that makes it really clear, as the firm, as the agent, you're representing only one side on the transaction, the buyer. However, if you're with a really great firm, there's a really good chance that you one day will want to show a property listed by your firm. Now you have a buyer who's represented by the firm and a seller who's represented by the firm, and that is what we call dual agency. Now this contract, I think, does a wonderful job of explaining what agency is, when you have to disclose it, what the roles are, what really happens. But at the end of the day, what's really important is that they understand what dual agency is, what designated dual agency is, and what authorizations they're willing to make. By that, what I mean is, as a buyer's agent, even before you show a house that is listed by your firm, you need to make sure that both your buyer and the seller of the home have agreed to dual agency. That means on their contract, right here on ours where it says dual agency, and the seller's contract is very, very similar, we want to make sure that they have initialed this line that says they authorize them to work as a dual agent. If either the buyer or the seller, because this is dual agency, both parties have to agree. If one of them says, no, I'm not okay with the firm representing both sides, then they would choose this exclusive representation. They would initial there. So if your buyer initials exclusive representation, you cannot show them any house listed by your firm. And if you're at a firm with multiple locations, that's going to be a problem. Now, if the buyer and the seller are both okay with dual agency, meaning they've both initialed here, right there, the next question they need to answer is, am I willing to let one individual agent represent both me and the seller? They have to make that choice, and they're going to choose either they do or they do not. And finally, once they've authorized dual agency, they need to decide whether or not they are okay with designated dual agency. And in designated dual agency, this is where the firm is acting as a dual agent, but they're going to designate one individual agent to represent the buyer and a different, if I can get it out, a different individual agent to represent the seller. In fact, when a buyer initials this, they are authorizing this and they direct the firm to designate those two people. So this is something you very much want to have a conversation with your clients about, because when you are a buyer's agent and you're doing showings, it is your job to make sure you do not unintentionally enter into dual agency, regardless if your buyer agency is oral or in writing, exclusive or non-exclusive. If you are showing a house listed by your firm, that is dual agency and both parties have to agree.
Okay, now see, it's hard to do that in brief, isn't it?
It is.
Just a couple of things here, not related to the test, but having said that, errors and omissions insurance, that is the number 2 claim, is dual agency. Why? Because it's a conflict of interest. And what happens is oftentimes these buyers come back and say, I didn't know you were also working for the other guy as well. Please take your time. Please read this. Also in class, if you're taking the pre or post right now, you need to be aware of when dual agency needs to be in writing. And as Kandyce mentioned, you can't even show a property unless you have the appropriate authorization at the time that is taking place. It's an extraordinarily important topic. We could spend an hour talking about this one topic.
We probably come close. But as we wrap up this dual agency stuff, I do like to point out this little line here that just reminds the buyer, look, this is a buyer agency agreement, but I'm probably going to get paid on the seller side too if you choose dual agency. Just be aware. So it's just something to point out, right? And notice it says this will in no way affect or modify the amount of the fee set forth in the paragraph above that the firm expects to receive for its services. Right? So we're agreeing, buyer, the firms should be paid X amount for helping you find a home. But don't forget that if you have dual agency, there'll be an additional amount that has nothing to do with your amount also in play.
And if you understand that, you will be better than 95% of agents, because no one understands that line.
They should now.
They should. You're right. They should.
Now, we don't ever want things to end. We prefer that your relationship ends because you find them a house. But sometimes your relationship is terminated and you can't hold a buyer in an agency agreement that they don't want to be in. But they do have a legal obligation to work with you, so they would be in breach if they just end things. Now, having said that, I'm not an attorney. Chris, are you an attorney?
I am not an attorney.
So you need to call an attorney to talk about what happens if somebody wants out of their agreement, and you most definitely want to talk to your BIC. But terminations do happen. And if it happens, if there's a breach or something like that, then we are agreeing that we're going to go through mediation before we start going to courts and involving judges. And of course, if I have to sue you for those attorney fees, there's probably not going to be a good thing there. And the person who's in the wrong is going to pay the other person's fees. All right. Anything else you want to add to that?
No, I mean, we on the buyer side, be careful about this, simply because, as I mentioned earlier, buyers oftentimes don't understand exclusivity, and they'll work with multiple agents. And think about this. If they go to a new home subdivision and buy a home, and they buy a home without me, then probably the agent that was with them at the time they bought the home is going to get paid by the new home's builder. But remember what this said up in paragraph 4. If they buy something during the term of this agreement, I deserve compensation as well. And if the listing agent's not going to pay it, then I expect you to pay it, buyer. So this comes up many times throughout the year.
And in fact, there's this note: the buyer should consult with the firm before visiting any resale or new homes or contacting any other real estate firm representing sellers to avoid the possibility of confusion over the brokerage relationship and misunderstandings about liability for compensation.
Yes, if you wonder how these notes end up being put in a note format with a box around it, it's because it does happen multiple times.
Now, as a reminder, we know that we want to keep agency and especially the purchase contract, anything that we want to add, it needs to be in writing. So this form is going to be our entire agreement, and any changes that we make need to be in writing, right? We want to remind our buyer that there's a good chance that you're being, is it surveilled? Surveilled.
There's a 100% chance that you're being surveilled.
Between Rings and Alexa and everybody else, just remember, even though it's illegal for people to record you, audio without your permission, more than likely it's happening. So just be aware of that. Right? And when we talk about photographs and video, I mean, it's the same thing. You just...
Yeah, don't take pictures in private parts of the house. If something's laying out, for the most part, it's kind of fair game, but be very, very careful about taking photos in a house that are going to show the seller's family, private parts of the house, or their private jewelry and things like that.
Right. So as we wrap it up, we have our wire fraud warning, because I'm pretty sure it would suck to be the buyer and not be able to buy the house because you were defrauded, wire fraud, or any other way. And then here we go. We know that the commission produces some Q&A brochures. So if you're having trouble explaining things or the buyer wants more information, point them to the commission website where it's free and they can look. Right? You got to make sure that you give a copy of this to your client. And then this is where everybody signs, whether it's the buyers themselves or the entity buyer. And what do I mean when I say entity buyer, Chris?
And they give you a short list underneath there, an LLC, a corporation, partnership. And again, guys, if you know that you're dealing with one of these, my recommendation is that you talk to an attorney. You're going to need the attorney anyway for closing, and ask them, hey, this person is an LLC. What documents do I need? Well, we're going to need something to show who has the ability to sign for it. We're going to need the organizational documents for the LLC. Why not go ahead and get them prepared just to avoid a mistake down the road?
I love it. Okay, well, we're going to sign on behalf of the firm all of this information, and that's where your signature goes, along with your license number. And then we are at the end of page 7.
Hey, tough question for you.
Yes.
Why is the license number on there?
Because you have to have your license number on there.
I often say that there are 5 rules by the Real Estate Commission on agency agreements. They have to be in writing. And as I mentioned a little bit earlier, please know when your agency agreements have to be in writing, they must have a start date and an end date. They cannot be automatically renewable. They must have standard non-discrimination language. And must have the agent's license number.
And that's what it is. Mine is 1-800-PERFECT. Or it could be 555.
Mine is really low because I got it a long time ago.
Well, that's it, guys. I really hope that you enjoyed this and it was helpful. Again, if you haven't checked out our other videos on the other 2 really important contracts, the offer to purchasing contract and the exclusive right to sell listing agreement, go ahead, because whether you're in pre-licensing or post-licensing or just out there on the streets helping people buy and sell, it's got some good information in there. And again, if you want more information on agency and how it all works, just drop a comment down below, because if that's something you want, we'll do it.
That could be said about any of these documents. True. If you have a transaction that you're struggling with and you want to have a video made about it, just let us know. Now, we cannot be your legal counsel, obviously, but we would be glad to make it on certain, especially the documents which we use on a regular basis.
Exactly. All right, Chris, say good night.
Good night, all.
All right, see you next time. Bye.
Bye-bye.